tracking down the electoral bond scheme as such. We are joined by Advocate Shadhan Farasat, who was appearing for the CPIM in the Supreme Court. Let's hear from him what is his take on the entire judgment.
So today's judgment is quite a far-reaching judgment in terms of for the functioning of democracy, in particular the transparency in its functioning. And the Supreme Court has struck down all the relevant amendments which introduced anonymity and was the basis then of the introduction of the scheme of electoral bonds. So basically the Supreme Court's view was, they agreed with our submissions, that effectively the public has a right to know who is funding their political parties. And you cannot have in a democracy a system where secretive funding is happening to political parties. And the court was of the view that even assuming that the central government's interest, that is that ensuring reduction of black money, is a genuine interest, this is not the way to go about doing it, because then what you are doing is you are attacking a counter interest of the public to know, and this was clearly disproportionate, and therefore the court struck it down.
So what is the direction for the SBI now to the election commission?
So the directions to SBI and election commission are that SBI will, because SBI was the banking agency which was actually responsible for actual layout and this thing of the electoral bond scheme. So they have all the data. So they have been asked to give all the data of the purchasers and where then the electoral bonds were encashed, so that a matching can be done effectively for who paid to who. And that data has to be given to the election commission within a period of 3 weeks. And thereafter, within a period of 1 week, the election commission has been directed to disclose that data on its website, which means that any citizen of India will have access to that data. And hopefully everybody can know as to how this scheme functioned and who were the beneficiaries, and if there was any wrongdoing or not. Those aspects can also be then eventually gone into.
So do you think this verdict, right before the general elections to be announced, this verdict come as a setback for the ruling party?
See, I would not, that's a political question, so I would not want to answer it. But the question really is that this matter itself has been pending for a while. These are 2018 challenges. So it was good that the court finally took it up and has decided in a very comprehensive and clear manner. Any time can be a good time or a bad time for somebody or the other. So I'm not going to go into that. But really, for the purpose of electoral politics, this is actually a very, very good decision.
But the centre's claiming before the Supreme Court that the policy was completely transparent. It was aimed to protect the donor from the intimidation if caused by the political party later on after the elections. What's your take on that, sir?
So see, obviously those arguments at some level have not been accepted, because the court, I will see the fine print if that specific argument has been dealt with by the court. But broadly speaking, the point really was that, and the court has protected the small man's or the small woman's right to have privacy while funding. That also the court has protected. The court has said that yes, an individual, where I donate, who I donate to, if I'm donating 15,000, 10,000, is protected by privacy. But the doctrine of proportionality will cease to exist as you go up the ladder. So it can't be that I will donate crores and then claim privacy. That's what the court has said. So the point really is that if you're a big donor, obviously the intent is that you want to influence the outcome of what the governmental decision will be. And then you lose the right of privacy, which is the core which the electoral bond scheme sought to address. It was really for the big donors. It was not for the small man or for the small woman to donate to political parties.
So the big game change is all set to begin now.
Let's see, the point is that we have had a system even before the electoral bond scheme. So that same status quo is effectively restored. But in the meantime, thousands of crores political parties have used these funds. Now we'll have some transparency about it, and it will be out in the public domain. And I think the public can make its own decisions based on that kind of a data as to what happened during the scheme.
So what happened to the uncashed electoral bonds?
Uncashed electoral bonds which have been uncashed as of today, when the judgment has been pronounced, the direction is that those shall be returned to the bank from which they were issued, and obviously the money will be returned from.
So the judgment is effective from today itself?
Yeah, straight away. The judgment is effective today, and I think even the conclusions and the outcomes were very clearly clarified by the Chief Justice when he read out. It will also be clear once the judgment is uploaded. But it's effective straight away, and even so, if as of today, as of this morning, anybody has a unencashed electoral bond which has not been deposited, that can't be deposited any further. You will have to return it to the bank from which you took it and take the money back.
Electoral bond scheme पर तुरंत रोक लगा.
So here we are with Advocate Shadhan Farasat, who clearly told that it is a setback for the centre as the electoral bond scheme comes to an end. From New Delhi, this is Kanu Sarda for India Today.